Chapter 6. Subrogation and TBS Administration of Estates. 202. Subrogation of executor or administrator to debts and legacies which he has paid. If an executor or administrator pays debts of the estate out of his own means to the value of the assets in his hands, he may apply these assets to reimburse himself, and by such election these assets become his own property. But his subrogation will be carried to no greater extent than the actual value of his payments. So upon his payment of his testator's debts, he will be subrogated to an equitable charge upon property charged by the will with the payment of debts, but will not become the absolute owner of such property. And although an executor ordered to sell land cannot himself retain it, as he may personal assets, yet if the personal estate proves to be insufficient, and he has paid debts of the estate to the value of the land out of his own property, he may, upon a sale of the land, retain the proceeds of the sale for his own indemnity. His right to be reimbursed for advances properly made for the benefit of the estate is paramount to the claims of the distributees. So, if he has paid debts of the deceased to an amount exceeding the available personal assets, he may for his indemnity be subrogated to the rights of the creditors whom he has paid against the lands of the deceased, and may subject the real estate in the hands of the heirs for his reimbursement, and a surety of the administrator upon his payment may be subrogated to this right of his principal. Though an administrator acts at his own peril in paying unpreferred debts of his intestate before he could lawfully be called upon to pay them, and if the estate afterwards turns out to be insolvent cannot charge it with the full amount so paid by him, yet, in the absence of statute regulations, he may, by subrogation to the rights of the creditors whom he has thus satisfied, receive the share of the assets to which they would have been entitled, and the same rule will be applied to any other trustee. But if his payments were made for his own relief, they will not give him a right of subrogation to the prejudice of other creditors of the deceased. An administrator who has made voluntary payments to a creditor of the estate will be protected by a subsequent decree in favor of such creditor. If he has employed assets of the estate to pay a debt owed by a legatee, he can hold only such legatee's share of the estate for his reimbursement. But he may be subrogated to the rights of a legatee whom he has, even before the probate of the will, advanced the money to pay. If one of two personal representatives has committed waste by applying the personal estate to the payment of debts, which were properly chargeable upon the real estate, the other representative, if compelled to replace the amount so misapplied by his colleague, may hold the real estate in the hands of the heirs for his reimbursement. For co-executors are not at the common law responsible for each other's waste, in which they have not participated, unless it has been made possible through their negligence. And one executor who has paid legacies that should have been paid by the other may be subrogated to the benefit of security given by that other for their payment. 203. Such subrogation must be seasonably claimed. Its limitations. The claim of personal representatives to be substituted to the rights of creditors whom they have satisfied must be seasonably made. Though an executor who has, in pursuance of a bond given by his testator, made a deed with covenants of warranty, on which he has been sued and subjected to the payment of damages, is entitled to be subrogated to the rights of the obligee in the bond, and thereby to be reimbursed out of the estate. Yet, if the estate was settled in chancery, and the executor, with notice of the claim, failed to have this subrogation provided for in the decree for the settlement of the estate, he cannot afterwards, without explanation of his lashes, maintain a bill for his reimbursement against legatees to whom he has paid their legacies. Or if his course of administration has been irregular and without regard to the rights of creditors, as by paying simple contract debts and leaving specialties unpaid, his claim for reimbursement has no right of priority on a deficiency of assets. He must show that property charged by the will with the payment of debts has been faithfully administered and has proved to be inadequate, before he can be allowed a lien upon the testator's other estate for his indemnity. If an administrator has in his hands the proceeds of property sufficient to pay a preferred mortgage to which it is subject, and instead of paying the mortgage debt pays another demand, he cannot recover back the latter payment if the fund subsequently, by reason of his own lashes, becomes insufficient to pay the mortgage debt. Though any trustee who has in good faith paid out his own money for the protection of the trust estate by discharging claims against it, is entitled to relief by subrogation to the rights of the creditors whom he has thus satisfied, yet this subrogation to the rights of creditors to whom he has paid more than their proportion of the assets will not be for his own benefit, but for the protection of those creditors who have not received what they were entitled to demand. 204. Subrogation in favor of creditors of deceased. Marshalling of assets. The equitable rule adopted in the marshalling of assets, that where one creditor may resort to two funds for the satisfaction of his demand, another creditor who can hold only one of these funds may compel the former to take his satisfaction out of that to which the latter has no resort, is of general application in the settlement of estates, especially in those cases in which one class of creditors can avail themselves of both the real and the personal property of the deceased, while another class is restricted to the personal assets. If the creditors of the former class exhaust the personal estate, those of the latter class will be subrogated to their rights against the real estate, to the extent to which the former have appropriated the personal estate for their satisfaction. If a testator had purchased an estate in his lifetime, and after his death the purchase money is paid out of his personal assets, the right of his simple contract creditors, if necessary for their satisfaction, to be subrogated to the vendor's lien upon this estate against the devises thereof, though at first left undecided, has since been established. But the creditor of an intestate is not, in the absence of special circumstances, entitled to be substituted to the rights of the heirs in respect of a debt due to them as such heirs. Creditors who have been postponed because of a belief that all property had been discovered and exhausted may, upon the discovery of further assets, be subrogated to the rights of those to whom they were postponed. 205. Creditors subrogated to a charge upon property purchased from funds of the deceased debtor. If an administrator or other trustee purchases property with the A88 ets of the trust, the creditors and cestuis qui trustant may in equity treat such property as part of the trust estate. Where a widow, before the appointment of any administrator upon the estate of her deceased husband, used his assets in making a partial payment for land which she purchased, giving her note for the remainder of the purchase money with a surety, and the surety afterwards paid the note, and took a deed of the land for his indemnity, it was decided that this surety held the title to the land in trust for the creditors and distributees of the deceased, subject, however, to his own prior lien for what he had been compelled to pay as surety upon the note. This is an application of the familiar rule that the beneficiary of property which has been impressed with a trust character may follow the proceeds of such property into the hands of any one, but a bona fide holder for value without notice. 206. Creditors subrogated to rights of executors to reimbursement. Though creditors who have made advances or rendered services to a trust estate must ordinarily look to the trustee personally for their payment, yet if the trustee would be entitled to reimbursement from the estate for his payment, and is insolvent or a non-resident, equity will substitute the creditors to the rights of the trustee, and allow them to be paid directly out of the estate. On the same principle, since executors who are empowered by the will to carry on the testator's business after his decease, though personally liable for the trade debts thereby contracted, may in equity reimburse themselves for their payment of such debts out of the property which has been lawfully embarked in the trade creditors may themselves in equity resort to this fund, if their remedy against the executors is unavailing, and may even hold the fee simple of land used for the purposes of the business. But such creditors must look primarily to the property used in the business, and cannot hold for the payment of their claims lands of the testator which he has not by his will subjected to the risks of trade, merely because the executors have without authority used the proceeds of the business for the improvement of such land. The rights of the creditors, being against the executors personally and only derivatively against the estate, cannot be greater than those of the executors for whom they are substituted. And accordingly, if the executors, being themselves in default to the trust estate, would not be entitled to indemnity except upon condition of making good their default, the creditors are in no better condition and cannot have their debts paid out of the fund unless the default is first made good. Debts thus incurred by the executors, though having equal standing as among themselves, must be postponed to the proper debts of the deceased. But in the absence of such considerations, where trustees who are authorized to carry on a business contract properly debts, The creditors may not only hold the trustees personally, but may also resort to the trust fund for their payment. 207. Where the creditor entitled to hold two funds. The common law rule that the personal estate of a deceased person will be applied to the payment of high debts to the relief of his real estate will not be enforced when it is in apparent hostility to the intent of the deceased as expressed in his will, and would defeat bequest made therein. In a case in New York, it appeared that a deceased citizen of that state had by his will authorized high executors to reduce all the property real and personal of which he should die possessed in America into divisible shape, and after the payment of debts and testamentary expenses to divide it into 7 shares, and distribute these in a specified manner. When he executed his will, his property was mostly personal, but he afterwards purchased real estate in South Carolina, paying part of the purchase money in Cub, and giving his bond secured by a mortgage on the land for the remainder. The will was admitted to probate in New York as a will of both real and personal property, but in South Carolina only as a will of personal property, not having the number of witnesses required by the laws of that state for a will of real estate. All the legatees under the will were aliens, except the beneficiaries of one of the shares, to whom as heirs at law the real estate descended. The holder of the mortgage bond presented it as a claim against the estate, and the Court of Appeals held that to pay this bond out of the personal estate would defeat the obvious intent of the testator to have all his real and personal estate in this country divided equally among the beneficiaries under his will, and that the doctrine of two funds would be applied by requiring the bond creditor to exhaust his remedy under his mortgage against the real estate before resorting to the personal property, which alone was available to the claimants under the will. When a court of equity has control of both the real and the personal estate, it will, in order to save expense and delay, apply them in the order in which, as between the heir and the executor, they are liable. 207a. Subrogation between tenant for life and remainderman. Where a testator devised all his estate, both real and personal, to his wife for her life, with remainder over, and directed his executrix to pay his debts as soon as possible out of any funds which she might obtain for that purpose, it was held that the tenant for life and the remainderman must contribute for the payment of debts according to their respective interests, and that advances made by the tenant for life for that purpose constituted a lien upon the estate as against the remainderman. The same rule has been applied in other courts, where a husband conveyed land which was subject to a mortgage for his own debt, to be held in trust for his wife for her life, with remainder in one half to her heirs or divisees, and in the other half to his heirs or divisees, it was held that she might for the protection of her estate pay off this mortgage, and that she having done so, her divisees were entitled after her death to hold the mortgage lien upon the whole tract against her husband's heirs, until the latter should contribute their equitable proportions of the principal, sum due on the mortgage debt, and of the interest accruing after her death, as it was her duty to keep down this interest during her life. The redemption of the tenant for life is for the benefit of the remainderman as well as of himself, upon the remainderman's contributing his proportion of the expense. Until this is done, the tenant for life can insist upon being subrogated to the original lien. 208. Subrogation in favor of legatee. A legatee will be allowed the same right of subrogation as would be enjoyed by a creditor. If the personal estate of a testator, not being sufficient to pay debts and legacies, has been exhausted by the executor in the payment of creditors, whose debts are chargeable on both the real and the personal estate, a legatee, as between himself and the heirs, is entitled to stand in the place of the creditors pro tanto, and to receive the amount of his legacy, or so much thereof as the personal estate, but for such creditors would have paid, out of the real estate descended to the heir, unless it appears by the will that the testator intended the legacy to abate in the case of a deficiency in the personal property. Where a testator, having agreed to purchase an estate, died, leaving the greater part of the purchase money unpaid, a legatee was allowed to have the assets marshaled in respect of the vendor's lien for the unpaid purchase money, so that his legacy might be paid, and if such purchase money has been paid by the executor, and the personal assets of the estate have thereby been exhausted, a pecuniary legatee will be subrogated to the vendor's lien upon the purchased estate against the divisees thereof. Where a debt of the testator is primarily chargeable upon lands which he has specifically devised, and the creditor obtains his payment out of the personal estate, or from other property which is only secondarily liable for the debt, the owners of such personal estate or other property are entitled to be subrogated to the rights of the creditor against the estate specifically devised. And to prevent certity of action, the court in such a case will permit, and sometimes require the creditor, who can hold two funds for the satisfaction of his demand, to proceed at once against that fund which is primarily liable, without subjecting the owners of the secondary fund to useless litigation. If an annuity which was charged by the will upon both real and personal estate has been satisfied from the personalty, leaving that insufficient for the payment of the general legatees, the latter will, as against the heirs, but not against divisees, be subrogated to the lien of the annuitant upon the real estate. 209. In favor of a purchaser from the personal representative. The purchaser of a deceased person's real estate at an invalid sale made thereof by the personal representative for the payment of debts, having paid his purchase money, and this having been applied to the payment of debts and charges of administration, is entitled, upon an avoidance of the sale, to be subrogated T0 the rights of the creditors and of the personal representative whom he has satisfied, and to charge the land with the debts and expenses so paid by him, to the extent to which the land was liable for such debts and expenses. The land will, for the protection of a purchaser, be charged with the debts which have thus been paid out of his purchase money. A purchaser of personal property from a guardian will be protected in the same way. This right of a purchaser has already been considered, but it has been said that if the title of the purchaser fails by reason of a want of jurisdiction of the court ordering the sale over die heir, the purchaser will not be so subrogated against them, the debts paid not having been liens upon the land. Though a purchaser of land of a testator at a sale thereof made under a judgment against the executor acquires no title by his purchase, yet if he pays his purchase money in good faith, under the belief that he is acquiring a good title, and this is applied to the payment of the judgment debt, which was charged upon the land by the will, he will be subrogated to the benefit of this charge, and will be allowed to hold the land until he has been reimbursed to this extent. But the mere fact that the purchase money has been applied to the payment of the debts of the deceased will not entitle the purchaser of his real estate from the administrator to a lien upon the land for his reimbursement upon the sale being set aside, if such debts do not appear to have been a charge upon the land. Nor, if the administrator puts himself in the place of the purchaser, can he, as a relief against his own wrong in making the sale, claim the subrogation which might have been allowed to the innocent purchaser. 210. Where legatees have paid judgments against the estate. Legatees who have paid a judgment rendered in favor of a creditor of the estate against the executor have, for their reimbursement, the right to be subrogated to the remedies of the judgment creditor, if the claim of the creditor was reduced to a judgment, or otherwise made a lien upon the assets to which the legatees are entitled to look, but not otherwise. For one who pays a debt for which he was not personally liable, and which was not a charge upon his property, will not be substituted to the benefit of a lien which the creditor had upon the estate of his debtor. So where an executor, who was also a divisee and legatee, died insolvent, having wasted a large portion of the estate, and leaving unpaid a debt of the testator, and also a judgment against himself for his own debt, which judgment was a lien upon his interest as divisee in certain real estate of the testator, it was held that his co-divisees and legatees did not, by paying the debt of the testator, acquire a right over his interest in the real estate prior to the lien of his judgment creditor, either by substitution to the claim of the creditor whom they had paid, or by reason of the executor waste. But if a testator has bequeathed all his property to his widow in lieu of her dower, and she has as his executrix paid from the general assets notes given by him in payment for an estate which he had bought subsequently to the execution of his will, and which did not pass thereby, she will be subrogated for her reimbursement to a lien retained by the vendor upon the estate to secure to him the payment of these notes, and this right will pass to her divisee. So if money of her husband's estate that should have been paid to her for her dower interest has been exhausted by the administrator in the payment of debts, she may be subrogated to the rights of the creditors who have thus been paid at her expense to hold the real estate for her reimbursement. 211. Subrogation in favor of specific divisees and legatees. the devise of a tract of land which by direction of the testator had been levied upon in his lifetime to satisfy a debt of his own, and was still bound by the levy at the time of his death, is entitled after paying the debt to be subrogated to the claim of the creditor against the personal assets of the estate, and the lien creditor of the devise will have the same right of subrogation. For unless the will manifests a clear intention to the contrary, it is the right of such devise to have the testator's indebtedness paid out of the personal and undisposed of assets of the estate, though this rule is reversed when devised property is subject to a charge which is not the proper debt of the testator. But this right will not extend to a grantee of the devise whose grant is expressly made subject to the encumbrance upon the land. And in England and New York real estate, which is subject to a specific lien for the payment of a debt, as in the case of a mortgage, is prima facie the primary fund for the payment of such debt, to the exoneration of the personal property. Since specific legatees are entitled to receive their bequest exonerated from encumbrances created by the testator, they have likewise, if their legacies have been sold for the payment of the testator's debts, the right to resort to the general fund for their remuneration upon the principles adopted in the marshalling of assets. If this general fund is made up partly of personal estate and partly of the proceeds of real estate, not chargeable with the payment of simple contract debts, that portion of it which comes from the personalty is liable in the first instance to make up for the loss of the specific legacies, and if that be insufficient, then the proceeds of the real estate are to be applied for the same purpose, so far, and so far only, as the specific legacies have been appropriated for the payment of specialty debts which bound the real estate. 212. Subrogation of devises to subsequently acquired assets. Devises who have lost the whole or part of the property devised to them by its being sold to pay the debts of the testator, in consequence of the insufficiency of the personal assets, will be subrogated to the rights of the creditors whom their property has thus satisfied, and entitled to reimbursement out of personal property subsequently discovered and received by the executors. And such a devisee's right of subrogation will pass by an assignment of all his share and claim in and to the personal estate of the testator, which then was in or might thereafter come into the hands of the executors, although not mentioned in the assignment, and not appearing to be then known to the assignor. Accordingly, where a testator charged his personal estate with the payment of his debts, but this being insufficient for that purpose, the testator's real estate, which had been devised, was sold to pay his debts, and afterwards the executors obtained a sum of money upon a claim which the testator had against the French government. It was held that this money was in equity to be considered a substitute for the real estate which had been sold for the payment of debts that were primarily chargeable upon the personal estate, and that in equity it must go exclusively to the devisees or their grantees, who were at the time of the sale the owners of the real estate that had been so sold, this money being regarded not as real estate, but as a fund to which they had an equitable right to compensate them for the loss of their land. But creditors of such devisees, though having acquired a judgment lien, can be subrogated to this right of the devisees only by bringing all parties before the court, so that the rights of all may be properly protected. 213. Rights of heirs, devisees, legatees against each other. If one of several devisees has lost the property devised to him by its being taken to pay a debt of the testator, he will be so far subrogated to the rights of the creditors whom he has thus been forced to satisfy, as to be entitled to a contribution to his loss from the other devisees, and an heir will have the same right against the other heirs. He will also be subrogated to the rights of the creditor against another debtor who is under a primary liability for the payment of the debt. The different devisees, if there be a deficiency of assets, must contribute to meet a charge upon all the estate devised, in proportion to the value of their respective interests, as to make up an annuity to the testator's widow, or to pay debts of the testator which remain unsatisfied after the personal property and the undevised real estate have been exhausted. A devisee whose estate has been taken for the dower of the testator's widow has the same right to contribution as if it had been taken for a debt of the testator's. A legatee who has advanced money to pay the testator's debts under the mistaken suppositiate that they were charged upon his property has been allowed to compel contribution from his co-legatees. Where legacies and devises are put upon an equality, they are equally liable to contribution among themselves. But a residuary divisi is not entitled to contribution from the other divises, though a somewhat modified rule has been laid down in England. A divisi of land who has been obliged to pay a debt of the testator which was primarily charged upon the land devised to him cannot claim contribution therefore from other specific divises or legatees. In Mississippi, it is said that the doctrine of the marshaling of assets does not apply to the queue of specific legatees under a will when all the property bequeathed to them is subject to an encumbrance paramount to the will of the testator, and the property bequeathed to one of them has alone been seized to satisfy this encumbrance. And accordingly such a specific legatee will have no right to enforce contribution from his co-legatees, though their property was equally liable with his to the burden of the encumbrance, thus leaving it to the caprice of the creditor to determine at whose expense he shall get his payment. And on the principle that no one can enjoy, by way of subrogation to a creditor, any greater rights than the creditor himself possessed, it was held that where one died, leaving unencumbered real estate, and also real estate subject to a mortgage by the terms of which the mortgagee could hold only the land for the satisfaction of his demand, and the mortgagor's heirs made partition among themselves of all his land in ignorance of the mortgage, the heir who afterwards lost his land by the mortgagees taking it could not be indemnified for his loss from the personal estate of the deceased. Nor can a divisi who has lost his estate for lack of title in the testator be relieved out of other portions of the testator's property. 214. Specific devise of legacy chargeable with expense incurred for its protection. If an executor has at the request of divisees relieved the devised property from an encumbrance resting upon it, he may for his reimbursement, as against the divisees, be subrogated to the original charge upon the property, the general doctrine being that a trustee who removes a prior encumbrance upon the trust estate will be subrogated to the lien of that encumbrance for his protection. An executor who has properly paid out of the general estate taxes and liens, primarily chargeable upon land specifically devised by the testator, and which should have been paid by the divisees thereof, may, in case of their failure to reimburse him, be subrogated to the liens upon the land, and may have these liens enforced for his protection. Though co-legatees do not sustain to each other the relation, al co-sureties for the testators, debts, each being responsible in any event only in proportion to the amount of his own legacy, yet if one of two residuary legatees has incurred in protecting their joint interest and expense which is proved to be beneficial to both of them, he will be entitled to recover from his co-legatee reimbursement to the amount of the expense incurred upon the latter's account, at any rate if the latter neither objected to the incurring of the expense nor himself provided for the protection of his interest. The expenses of a necessary litigation will be thrown upon the whole fund which reaps the benefit thereof. 215. Rights of heirs among themselves. If some of the heirs of an intestate held a mortgage upon his real estate to secure the payment of a debt due to them from him, and in order to prevent a sale of his real estate by his administratrix give bond for the payment of his debts, though they will thereby discharge the lien of their mortgage as a security for the debt due to themselves, they may nevertheless hold the mortgaged premises against the other heirs as if the mortgage still subsisted, until these other heirs shall contribute their respective shares of the mortgage debt. If exempt property is sold by the administrator to pay debts, the heir is entitled to be reimbursed from such other property as is not subject to prior liens. And if debts which were chargeable upon the personal property have been paid out of the real estate, the heir may, as against the distributees, be subrogated to the rights of the creditors upon the personal estate. But he will not be so subrogated against the divisees to reimburse him for debts which he has paid out of his own pocket as a mere bounty. 216. Rights of purchaser from heirs or devise. If the purchaser from an heir at law of a portion of the real estate descended to the latter subsequently loses the land which he has purchased by its being sold to pay the debts of the ancestor, such purchaser will have an equitable lien upon the residue of the property remaining in the hands of the heir for his reimbursement. Such a purchaser, as to the land remaining in the possession of the heir, stands in the position of a surety, and will be subrogated to the rights of the creditor whom his property has satisfied, as if he were a surety. And if successive conveyances of lands have been made by an heir, or by a divisee thereof charged with the payment of debts or legacies, the lands thus conveyed are, in the hands of the purchasers thereof, liable among themselves to be resorted to for the payment of such debts or legacies in the inverse order of their alienation, the portion, if any, remaining in the hands of such heir or divisi being first taken, then the portion last conveyed by him, and so on. In the same way, bona fide purchasers of the property of the testator from executors who have power to sell the same will be protected from debts of the testator, which are liens upon the purchased property, by compelling the executors, if they have assets, to pay such debts. 217. Creditors subrogated to the rights of legatees. If a testator charges one estate with the payment of his debts, and another with the payment of legacies, and the legacies are paid out of the proceeds of the former estate, the creditors will be subrogated to the rights of the legatees against the latter estate, in the hands of a purchaser thereof who had constructive notice of the terms of the will, and sureties who have satisfied the creditors will have the same right which the creditors might have exercised. The legatees, said Moncure P., having received payment out of the fund which belonged to the creditors, the latter had a clear and plain right to compel the former to refund the money, so far as it was necessary for the payment of debts. And the legatees, being thus disappointed in obtaining satisfaction out of the fund which belonged to the creditors, would have as clear and plain a right to be reinstated in their charge upon the home place, and to be satisfied out of the same. But to avoid circuity, a court of equity will subrogate the creditor to the place of the legatees, and give the former a direct decree against the home place. So, where an executor who was also a trustee under the will applied the funds of the estate, which should have been used to meet the testator's debts, to pay charges which constituted a superior lien upon the trust property, it was held that equity would give the general creditors a charge upon the trust property to the extent of such payments. 218. Subrogation of divisi or legatee who is disappointed by the election of another. Beneficiaries under a will who have, by the election of another legatee, been disappointed of what they would otherwise have received, will be allowed compensation for their loss out of what the latter would by a different election have taken under the will. If a legatee, under a will which devises away property belonging to himself, elects to retain his own property and to waive the legacy, the testator will not be thereby rendered intestate or the share of the residuary legatees, not being the parties disappointed in consequence of the election, increased as to the subject matter of such legacy, but it will go to the disappointed divisi, so far as is necessary to the satisfaction of his loss. So, if a testator bequeaths the income of certain property to his wife for the support of herself and her children, and she waives the provisions of the will in her behalf, and elects to take her dower rights instead thereof, the children will be entitled to the whole of the income of that property for the time that she would otherwise have taken it. Divisees whose interests are prejudiced by the widow's election to take her dower in preference to the provision made for her by her husband's will are equitably entitled to compensation for their loss out of the provision which she has thus rejected. The ground of this doctrine was stated in an early case to be that where a testator, in making provision for the different branches of his family, gives a fee simple estate to one and a settled estate to another, imagining that he had power to do so, a tacit condition is annexed to the divisi of the fee simple estate, that the divisi thereof shall permit the settled estate to go according to the terms of the will. And if in that respect he should disappoint the will, what is devised to him will go to the person who is thereby disappointed, it being presumed that, if the testator had known of his lack of power to devise the settled estate, he would out of the estate in his power have provided for that branch of his family which had no interest in the settled estate, and have directed that no person should enjoy a devise or legacy who controverted his power as to a bequest given to another. The will thus be upheld, and the intent of the testator carried out, as far as this may be done. Accordingly, this doctrine will not be applied to the case of a person who disappoints another by electing to take under the instrument which gives rise to the election. 219. Extent of this right of substitution. The substitution of the disappointed beneficiaries to the rights of the legatee or divisi, whose election has caused the disappointment, will, if necessary, be to the extent of the rights which were given by the will to the party making the election, but it can be carried no further. If the widow of a testator who has by his will, after various absolute devises and bequests, bequeathed the income of a certain fund to his wife for her life, with remainder to be distributed among various legatees, and given the residue of his estate to his residuary divisees, elects to take her statutory rights as widow in his estate, instead of the provision made for her in his will, and thus diminishes the share of the residuary legatees, these legatees will, during the lifetime of the widow, by substitution to her rights, be entitled to receive the income of the fund provided for her, and after her death the fund will go to the legatees named in the will, as if her election had operated no change in carrying out the intentions of the testator. The purchaser from a divisee of certain cottages in which the testator had only a life estate, the remainder being in his wife, will be entitled to compensation from the estate of the testator's wife, for her selling the cottages to the extent of the benefit taken by the wife under the will, the testator having given all his estate to his wife for her life, and these cottages after her death to such purchaser's grantor. A testator, having charged certain lands with a portion for his daughter by his first wife, afterwards settled a portion of the same lands as a jointure upon his second wife, who had no notice of the prior charge. Believing that the charge would have preference over the jointure, he then devised other lands to his wife in lieu of the jointure. After his death, the wife, finding that her jointure was good against the charge for the daughter's portion, because the latter was merely voluntary, agreed with the heir to waive her devise and claim the jointure, for the purpose of depriving the daughter of her portion. But the court decreed that the daughter should have the lands devised to the wife until her portion was made up. 220. This does not extend to a devise merely upon condition. If property is devised to one upon a condition with which he fails to comply, and thus waives his right to the devise, the performance of this condition by a stranger will not substitute the stranger to the rights of the divisee. Thus, where a testator devised land to one of his sons on condition that the divisee should support a second son during his life, but the divisee refused to accept the devise, and did not support the second son, and a stranger, having been appointed guardian of the latter, advanced out of his own means money for his support, to an amount equal to the value of the estate so devised, it was held that these advances could not rightfully be reimbursed out of the devised estate, but that, on the refusal of the original divisee to accept the same, it descended to the testator's heirs at law, free of any charge thereon. But elsewhere the right of a party furnishing support to the beneficiary of such a conditional devise or conveyance to be subrogated to the title of the divisee has been affirmed. If a person to whom land is devised, on condition of his releasing a debt clue 6 to him from the testator receives payment of the debt, he relinquishes the land. And the fact that he received such payment from a stranger gives the latter no title to the land. But if the money so paid by such stranger was the full value of the property, and immediately upon its payment ye took possession of the land, and was suffered by all the heirs to hold possession, they knowing and acquiescing in his payment, and he incurred expense to make improvements, it has been intimated that equity would order the land to be conveyed to him, especially if the title was one which was then governed as to its transmission by the same rules as personal property. And a devise of land on condition that the divisee shall pay certain specified debts and legacies creates a charge upon the land, to the exoneration of the personal property bequeathed by the will, although the devise be not accepted.